Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Well, good morning, everyone. Today is Tuesday here at 10 a.m. Pacific time on the Bottled Business Sense show. I'm Rick Moscoso, one of your co-hosts today. I want to welcome you to our second episode here in January. Hope everyone had a great new year. We have an expert on the other side, my friend, cohort, and co-broadcaster, Mr. Bill Bernard, and I want to welcome him into the episode. And if I haven't told you already, Bill, Happy New Year.
Yeah, Happy New Year to you, Rick. Glad to be here again. Another year, man. The years fly by, dare I say, as we get older, they seem to fly by quicker. But in any event, here we are. Again, our hopes are always to bring the best that we can for free to viewers so that they have some idea of what's going on in the business world, which, as we've said many times, encompass the personal aspect of estate planning, the specific business aspect of creating a business entity to run your business, and of course the power of protecting your assets by way of asset protection. We've always said that business encompasses all of these things and needs to be combined together, and so we try to do that, and we do it for free. Before we get started, Rick, where can everybody get if they want to watch this broadcast or if they want to just speak to us?
Yeah, absolutely. You can always contact us through social media, Facebook, Twitter, Google+, and LinkedIn. Just search for Bottled Business Sense Show, and you'll find us. We're all over the place. Or contact us directly via email at bottledbusinesssenseshow@gmail.com. If you have any feedback, requests for future episodes, or just want to reach out to us in general, maybe even be a guest on the show, just go ahead and reach out to us on any of those channels and email. And then Bill will give you information towards the end of the show on how to contact him directly if you have any questions in regards to this episode. So,
and our information, I gather, Rick, will be posted at the bottom of the specific episode on the Bottled Business Sense Show face page, right? Homepage.
Yes, absolutely. And then you can, by the way, you can also watch past episodes, and we have, about 4.5 years, close to 5 years of previous episodes on bottledbusinesssenseshow.com. So there's a whole host of resources there that you can look for, and just search up the topic of your interest, and we'll be there.
And lastly, Rick, I know my microphone conked out today, so we're working without one, or at least I am. The sound rather is okay on your end for taping?
Yeah, we're good with that.
Okay, let's get started. This show then is going to be about some questions I've received toward the end of the year, last year, and it's called Power of Attorney or Conservatorship versus Power of Attorney, or Power of Attorney versus Conservatorship, whatever you want to choose first. There have been some questions, and this usually deals with the area of assets and, of course, sometimes medical attention. And, of course, when you look at these issues, timing is everything. Both the power of attorney and a conservatorship grant authority to make decisions about financial matters of another person, a third party. And specifically, a power of attorney, of course, is executed in advance of any incapacity. And we'll get to incapacity and what that is in a minute. Excuse me. That's executed in advance by the person who wants to appoint an agent to act on his or her behalf. Whereas a conservatorship is done usually after incapacity occurs. Somebody wants to come in and have the court appoint them as the conservator of the estate to take care of financial and sometimes even health matters for the person who's become incapacitated. The key here is understanding that it's a court intervention, number one, and number two, it's usually can get pretty expensive, and you'll see why in a few minutes. The authority is usually limited to certain activities by way of a power of attorney. A power of attorney will come in and you'll be asked to do certain things under certain conditions, like maybe buy property out of state on behalf of the principal. If you have a durable power of attorney, you might have it last a period of time until the individual who has become incapacitated reaches capacity again, if that occurs. So the first example I gave would be a limited power of attorney where the person doesn't need to be, the principal doesn't necessarily need to be incapacitated. Rather, he's appointing an agent to act on his behalf for a specific purpose or over a specific limited period of time. A durable power of attorney usually occurs when someone has become incapacitated, and it can last until the person becomes capacitated again, if indeed that ever happens. Let's talk about incapacity a little, because I think that's important. A power of attorney is created again by a person who is competent at the time the document is created. However, a person is considered incapacitated, and therefore, if they don't have a power of attorney already, might need to have a conservatorship established by someone. Incapacity is considered, if it's we're not talking about a minor here, if a person is unable to make decisions for himself or herself and cannot adequately take care of his or her health or nutritional needs. Now, that's a big, we love it in the law to be very gray. We don't like black and white. So you're going to have something that's going to help establish this incapacity standard. Now, what would come to mind, Rick, common sense, what would come to mind is the first thing that would lead you to believe someone could establish incapacity? Who would that be?
Who or what?
Yeah, who? I got him stumped, folks. See, I've got him stumped already on this easy question. It's real easy. I'll give you a hint. Sawbones.
Sawbones. Oh, you doctor.
Yeah, of course. A doctor is going to have to come in, a doctor in some way, by some documentation or testimony or otherwise, going to have to say, yeah, Joe Blow is incapacitated. Here's why. Now, to initiate a conservatorship, you must file a petition and have a hearing scheduled, right? So the court may grant either a general or limited conservatorship depending on the level of the need of the conservatee. If the individual is mostly able to take care of himself or herself but needs assistance only with finances, well, then the person may be incapacitated to some limited extent or may simply just need help with finances. So a limited conservatorship will be granted by the court. The court might grant a full conservatorship if the incapacity, of course, affects something beyond just finances, such as the mind and the physical health of the conservatee. Now, what happens if someone files a petition for conservatorship where a power of attorney is already in place? What happens if the person was capacitated to handle his or her finances? Now someone files a petition with the court for conservatorship of that same individual, the principal. Well, the court may consider the existence of the POA, power of attorney, before appointing a conservator. The court is likely to honor the power of attorney, but it may also grant a conservatorship to help the individual with needs that the POA does not cover. So, for example, let's assume a conservator is handling the finances of an individual but needs help. The power of attorney agent is handling the finances of the individual, but now the conservatee needs help from a medical standpoint. A conservatorship can be granted on those terms. Also, the conservator who files the petition may come in and challenge the power of attorney agent and say, hey, he's ripping the guy off, the principal off, he's not competent, et cetera, et cetera. So those are the circumstances that might arise where you have a power of attorney in place and then someone tries to get a conservatorship established. I lastly just want to tell folks out there who need to know this, the steps to creating a conservatorship is going to be allowed by the court. One, you must file a petition. The proposed conservator must advise and serve the conservatee, the person that's going to be taken care of, and the relatives of the conservatee, and must explain the reasons why the conservatorship is necessary and why no possible alternatives are available. So the petition must be filed, and you must secondarily inform the potential conservatee and the relatives by delivering a citation and a copy of the petition to the conservatee, that is the person that is going to be taken care of by the conservator, and the relatives of the conservatee. Number 3, you must inform, I think I mentioned this, you must inform the conservatee's relatives, but here you can mail a copy of the petition along with the date for the hearing, as opposed to serving it personally. And you must do so by indicating that these documents, the notice of the hearing and the petition itself, is being mailed by someone other than the conservatee, so a third party. So if you're the proposed conservator, you can't mail these documents to the relative. A third party must mail, so that third party can be objective and neutral in case that third party has to testify as to whether or not properly served. You can't be a conflicted party doing the service and process.
So
Number 4,
it couldn't be my attorney, would it? Or who's the third party? Who would be the
conservatee? The conservatee is the person who's going to be taking care of the conservator. Cannot have the service sent by the conservator. If the conservator is an attorney, that would work, or have some third party mail out the notice and the petition to the relatives. Number 4, there's an investigation by the court investigator, who wants to know everything and anything about this conservatorship, because after all, they want to confirm that what's being said in the petition is in fact the case. And this is where the expenses run in, Rick. I mean, a conservatorship can go up to $10,000 and more just to get started. So it's not an inexpensive process. And last but not least, you have the hearing. That's number 5, where there is determination whether a lawyer needs to be representing the conservatee, the person being taken care of. The court will consider whether that person needs its own lawyer. The conservatee, the person being taken care of, again, must be present at the hearing unless excused due to illness. If granted, the court will file an order to appoint the conservator and issue letters of conservatorship to that conservator, so that conservator can prove to any financial institutions or anybody who's involved with the conservatee that he or she is in fact the conservator and has the power to act. So that's a brief description of the distinction between a conservator power of attorney and what happens when a power of attorney is already in place and a conservatorship has to be established. The court's going to generally take into consideration the authenticity of the power of attorney and may still appoint a limited conservatorship, or if the conservator who's filing the conservatorship challenges the agent for the power of attorney, that power of attorney could be negated. So there's a lot of issues going on there. But remember, conservators usually establish once the person already is incapacitated and doesn't have a power of attorney. The power of attorney is established before the person becomes incapacitated and therefore needs to become a conservatee. So there it is in a nutshell. I hope that's helpful to everybody listening out there.
Yeah, well, that's great information, Bill. And to some, like me, it's clear as mud. But that's why we have that's why we have experts like you to help anyone who happens to be going through this process, through the process in a smooth, an objective, and professional manner. So if you have any questions in regards to this episode, reach out to Bill.
Well, I hope it's a little less clear as mud, Rick.
No, he's just joking. But
I mean, in other words, if I was
it sounds to me that this can be a very messy and complicated situation if you try and do it yourself, or I would think people that are in the middle of this are very emotionally, or can be emotionally influenced.
Yes.
And not necessarily make the right decision. That's why you need somebody like Bill to help you and guide you through that process.
Well, let me ask you one quick little quiz question. If you were to take away the one major thing that you would take away from this presentation regarding the distinction between a power of attorney and a conservatorship, what would it be?
It sounds to me that it would be prudent to have the power of attorney in place first,
because you are a capacity.
Because you are of sound mind, right? Yeah.
Right. So the distinction would be, right, Rick, that a power of attorney, the focus of a power of attorney is it's something that's created by someone who has capacity, whereas a conservatorship is appointed by the court, usually by someone who petitions the court after that individual has lost capacity.
Right.
So that's the real distinction. And of course, as I said, a conservatorship can be quite expensive. So you want to try to have a power of attorney along with all your other trust documents, including the trust package that I always speak of, which includes powers of attorney for healthcare and assets, your trust, your pour-over will. We can go on and on and on concerning past episodes, and why I say prevent expenses later on by having the investment of a trust and all the attendant documents done up front while you still are clear, thinking, and ready to go.
That's right.
I hope everybody has gotten something out of this. I hope it's beneficial to those who have concerns over this, who are interested in this. And we have another show coming up soon, and we'll be together again to bring you another topic, which I believe is going to be something along the lines of what a hostile environment is in the workplace as it regards sexual harassment. So we'll see you then, right, Rick?
Stay tuned for the next episode here on the Bottled Business Sense Show. So thanks again, Bill. And to our viewers, we'll see you on the next episode.